speakers from abroad for the sessions of Beyond Law CLC in large number of sessions. But today we have a speaker who has been our resource person on various sessions, though he lives in Bangalore, but fortuitously he's in US. And as usual, he's always been kind enough, despite the fact that there's a time difference between the two. Yet he has agreed for the session on Mines and Minerals Development and Regulations Act of 1957, an important facet of law. And the speaker today is Vishwanath Angadi, a former principal city division and sessions judge, Karnataka, and an arbitrator. He will be explaining to us the procedure and practice of this important aspect. And without taking much time, since there was a time slag from our side because of some technical issues, we apologize for the same. But be that as it may, as they say, all good things have sometimes happenings which delay the process. But as they say, it's better to try and succeed rather than failing to try. Over to you, Mr. Angadi, and thank you for connecting us from the US.
Namaskar, Mr. Vikas. Namaste to all my viewers. I hope you had very good holidays. You enjoyed your Deepavali holidays. I once again wish you Happy Deepavali, though belated. The topic is the aspect of the procedure and also the law on mines and minerals. As we all know, it's a very important topic of study in any law courts and for advocates also. And my main stress will be in what ways in the law courts the advocates or even the judges they get perplexed in going further in some gray areas. So the point is to empower you on the aspect of practice and procedure, especially for the court cases. And this important topic of 1 hour, I will concentrate on the important subheadings or the scenarios. The first important point is in case of theft of minerals or sand from the riverbed of a river, which offences are in place and whether the police can take action or only whether the officers empowered under the Mines and Minerals Act they must take steps. The first question is for theft of sand, theft of minerals by any person, which important sections of the IPC and also Mines and Minerals Act they come into play. As regards the IPC sections, theft, as you all know, the section is 378 and 379 of the IPC, read with section 414 of the IPC. So theft, as you all know, common parlance of theft in section 379 and 378, that is the aspect of the offense. And for the same offense of theft of sand from a riverbed or even what is called as minerals, there can also be complaint filed by the officer authorized under the provisions of Mines and Minerals Development and Regulation Act. The section number is 22 of the MMDR Act. In that case, what about duty of the magistrate, duty of the special court? In case of theft of sand or minerals by the person or the offender or the accused involving the sphere of application of provisions of IPC, and number two, Mines and Minerals Act. The second important scenario is namely the truck carrying sand or minerals is seized by the police. Whether the JMC has the power to release the vehicle as an interim measure until the police files charge sheet before the said court or before the special court under MMDR Act or not. Release of vehicle or custody of the vehicle to the RC owner or the driver, the case may be, as an interim measure under Section 451 of CRPC, whether the magistrate had the power to release or whether only the special court has got the power to release it, because we have got special courts to deal with and try only the cases filed by the officers of the government under the provisions of the Mines and Minerals Act. The third point is whether the magistrate has got the power to direct the police to investigate the complaint filed by person on Section 200 of CRPC under Section 156 subclause 3 of the CRPC, even with regard to violations of provisions of Mines and Minerals Act or not. The question is, can JFC direct the police or the in charge person of the police station to investigate even on the offences involving the sections of the Mines and Minerals Act besides IPC or other offences and file charge sheet or not? What is the law on the point? The fourth point is namely penalties which the Act imposes on the offenders under the MMDR Act. The fifth point is special courts which are established now under provisions of the amended provisions of the Mines and Minerals Act. So since the last 6 years, we got special courts only for trial of the cases involving the sections of the MMDR Act being contravened by the accused or the offender. So with this brief prelude, I will take now quickly the aspect of sections of the Act which are important and then touch the legal niceties involving the above said sections, with which before law courts we are concerned infrequently. So the Act, the Mines and Minerals Development and Regulation Act consists as many as 33 sections. It has got 3 schedules, and the important sections are sections 3, 4, 4 capital A, 21, 22, 23, 23A, 23B, and 30B of the Act. These only are important for purpose of an advocate or for the law court with regard to the aspect of the procedure to go forward in a court case before a law court involving the application of the MMDR Act or otherwise, or along with the contravention of the IPC provisions. So this Act is enacted to provide for development and regulation of mines and minerals, and it is the central government which has the control of this particular branch of mines and minerals. So the central government is having the control of the Department of Mines and Minerals for the entire country. That is the purpose for which we have this Act. The next point is Union should take under its control the regulation of mines and minerals. That is so said in section 2 of the Act. So what it means is the central government is the authority which has to regulate and take steps for development of the branch of mines and minerals. Any law being made, any law being amended, any law being repealed on the subject of mines and minerals it's only central government which can do it. And state has no power to frame any policy, dehorse the provisions of the MMDR Act and rules made thereunder. The state government cannot enact any law which contravenes or conflicts with the central act or central rules on mines and minerals. And this is so said by the apex court in the case of manganese and iron ores limited versus state of Karnataka. The Supreme Court of India in manganese and iron ores limited versus state of Karnataka reported in 2010 SCC Part 1 at page number Part 13 at page number 1 held that state has no power to frame policy, dehorse or against the provisions of MMDR Act or rules made there under. So with this brief prelude, the next point is this act was in amended on 12th of January 2015. As per the said amendment, we now have the special courts under section 30 capital B of the MMDR Act. So amendment is made about 6 years ago, and we have got the last amendment made to the Act on 28th of March of the current year, under which the Act is further amended, allowing for transfer of the approvals and permits by a person to some other person, and that the restrictions on end use of captive minerals is now taken away as per the Amendment Act, which came into force on 28th of March of the current year. So we have got these two amendments in the current year and about 6 years ago, and I will touch at the appropriate point of time the important aspects of the amendments to the Act as per Act which came into force on 12/1/15 and 28/3/2021. So with this, the word regulation is defined by the Supreme Court of India in the case of Manohar Lal Sharma versus Union of India, 2014, Part 9, SCC 516. The apex court, in the context of this act only, defined the word regulation appearing in the act as meaning that it is under the control of the Department of Union of India, and that this applies even to the provisions of Coal Mines Act. That is the aspect of the apex court's decision. The word regulation is defined as rule or order prescribed for management or governance, so held by the Supreme Court of India in Saurashtra Cement and Chemical Industries versus Union of India, AIR 2001, Supreme Court, page 8. The next point is levy of tax or cess on minerals by states is not permissible as held by the Supreme Court of India in the case of P. Kannadasan versus State of Tamil Nadu. P. Kannadasan was the State of Tamil Nadu, AIR 1996, Supreme Court 2560. The apex court held that levy of tax or cess on minerals by states is not permissible. With this, I would take quickly with regard to various words used in the act with which we are concerned in the law courts infrequently. 3A defines the phrase leased premises. 3AA states what's called as minerals. Minerals means all minerals except mineral oils. So this act has no application with regard to mineral oils, which are petroleum and what's called as natural gas. And what is dug out from the earth need not always be a mineral. And mineral is defined by the Supreme Court of India in the case of V.P. Pitu Pithachi versus Special Secretary of Government of Tamil Nadu as meaning an inorganic substance found either on or in the earth which may be garnered and exploited for profit. The case of Supreme Court of India is reported in AIR 2003, Supreme Court 2455. With that, 3B defines the phrase mineral oils as meaning petroleum and natural gas. 3C is meaning of the phrase mining lease, which also includes sublease of a mining lease. 3D speaks of meaning of mining operations, that is, any operation which is undertaken for the purpose of winning any mineral, that is called as mining operations. And 3E is meaning of minor minerals. They are building stones, gravel, ordinary clay, ordinary sand. They are called as minor minerals. So stones were used to build a house, or gravel, ordinary clay, ordinary sand. They are called as minor minerals under section 3E of the Act. We got here the case of the Apex Court Promoters and Builders Association of Pune versus State of Maharashtra. That is 2015 Part 12 SCC page 736, wherein the Apex Court held in clear words that ordinary earth can be treated as minor mineral only for usages specified under the notification issued by the government under section 3E of the Act. With that, 3EA is what is called as notified minerals as per Schedule 4 to the Act, added about 6 years ago. 3G is prospective license. 3GA is meaning of prospecting come mining lease. 3HA is meaning of reconnaissance operations. 3H is meaning of prospecting operations. 3HB is meaning of reconnaissance permit given for the purpose of regional survey. Number 2, aerial survey. Number 3, geophysical survey. Number 4, geochemical survey. And lastly, what is called as geological mapping. We got this permit called as reconnaissance permit issued by government for these 5 purposes: regional, aerial, geophysical, geochemical, and lastly geological surveys, geological mapping as it is called. Then 3HC deals with the aspect of constitution of special courts by the government with effect from 2015. Then nextly and lastly, what is called as mine and owner under section 3I of the Act. What is called as mine? The word mine is not defined in MMDR Act. And there it states mine means as per the meaning, as per the Mines Act. And mine is simply a cavern or excavation in the earth. So mine is defined as excavation in the earth. Mine is called as excavation or cavern in the earth. So with that, the next point is section 4 of the act. Very important. You must have license for prospecting, for carrying out prospecting or mining operations. Without license of the government for carrying out prospecting operations or for carrying out mining operations, then it is said that there is contravention of section 4 of the MMDR Act. Section 4, 4.1 capital A, 4.1 capital B, that's said to be contravened. So 4 is the important section which states that without permit we cannot carry out what is called as mining operations or prospecting operations. 4 Section 4.1, 4.1 capital A, Section 21, Section 30B of the Act, they go together. 4.1, Section 21 and 30B, they go together as one sequence. And we should read Section 4.1 in the context of 4.1A, 21 and 30B of the MMDR Act. Section 4.3 states that the government should give to the licensee opportunity before terminating the license, affecting rights of the parties. The government wants to cancel the permit of the mining lease, even though the period is not yet expired. The government today thinks of cancelling the permit of the permit holder who has given license to carry out the mining operations, and for that also the Supreme Court of India in the case of Assam Sulimanite Limited versus Union of India AIR 1990 Supreme Court 1417 held that the government should give to the licensee of the mining lease opportunity before passing the order terminating the license, affecting rights of the lessee in question. So 4A speaks of termination of prospecting license, and we'll read it along with Rule 28 of Mineral Concession Rules of 1960. And we got here the case law of the Apex Court, that is reported in 2016 part 11 SCC page number 455, that is common cause versus Union of India, wherein the Apex Court held that the mining lease, though has expired, the said mining lease will be deemed to have been renewed for a period of 2 more years beyond the last date of the original lease. The Apex Court, in the case of Common Cause versus Union of India, held in clear terms that a permit, mining permit, though expired, it shall be deemed to have been extended beyond the term of the original lease for a period of 2 more years. That is the dictum of the Apex Court in the case of Common Cause versus Union of India, 2016, part 11, SCC, page number 455. So with that, the next point is what's called as period of prospecting license and reconnaissance licenses for a period of 3 years. And with all these things, we will not spend our time here, because we are dealing only with the aspect of practice and procedure. And here I will just tell you an important aspect. license issued beyond 2015 are for a period of 50 years, 50. So for the past 6 years, the government is issuing leases, mining leases for a period of 50 years. After expiry of the 50 years of the mining lease, the lease is to be once again auctioned, and there is no scope for renewal of mining license as was under the provisions of the old provisions. So for the past 6 years, we got the new provision which states that there is no scope for renewal, there is only scope for auction of the mining lease of a given area in question. And one more point is the 7 of the Act renewal can be renewal can be up to 20 years with approval of the central government, and that all these things are not touched because they are the spheres of the regulatory authorities, and before the law courts were concerned with the aspect of contravention of provisions of the MMDR Act. Then 9A speaks of dead rent to be paid by lessee. What is called as dead rent? What is called as royalty? This question perplexed the Supreme Court also. And we got here the case of D.K. Trivedi versus State of Gujarat. That is reported in AIR 1986 Supreme Court 1323. Dead rent is defined as rent payable on a mining lease in addition to royalty, and the same is payable whether mine is worked or not. So, dead rent is called as a fixed return to the lessor to be paid by the lessee, whether I use it or not. Say a tenant takes on lease a premises. He comes over to some other place for 1 year. But the law says, you tenant, you pay to the landlord the amount of rent, whether you use it or lock it or do whatever with the premises. Here also, dead rent and this royalty, dead rent is fixed, return payable to the lessor. Royalty is a variable return to the lessor. Royalty is calculated on the quantity of minerals extracted, whereas dead rent is calculated on the area of land. And these are the words of the apex court in D.K. Trivedi versus State of Gujarat, reported in 1996 AIR Supreme Court at 1986 Supreme Court, page number 1323. So with this, I'll take quickly 21 of the Act, that is penalties. For contravention of Section 21 surplus 1 of the Act, the punishment is up to 5 years and with fine up to rupees 5 lakhs per hectare of land. See here, the new provision of law is there. Per hectare of land, the fine is reckoned. So punishment is up to 5 years plus with fine up to rupees 5 lakhs per hectare of land. So 21.1 punishment is up to 5 years plus fine. That is amendment to the Act about 6 years ago by Act of 2015. Then secondly, breach of 21 plus 2 of the Act, punishment is up to 2 years or with fine up to rupees 5 lakhs or both. So for contravention of any rule made under the MMDR Act, so contravention of mining rules, contravention of state mining rules, as the case may be, that is 21 plus 2 of the Act, punishment is up to 2 years or with fine up to rupees 5 lakhs or both. And in case of continuation of the offences as a repeater, then additional fine up to rupees 5 lakhs for every day during which such contravention continues after conviction for the first such contravention. So for repeaters, under 21 plus 2 of the Act, we got this new section which states that for every day of continuation, levy rupees 5 lakh as additional fine. Besides 5 lakhs as per 21.2 of the Act, that is for repeaters or for offenders who contravene provisions of 20.2 of the Act again, and from date of order of conviction till the concerned date were to reckon at rupees 5 lakhs per day as additional fine. So that is 20.2 of the Act, Amendment to the Act about 6 years ago. 2023 speaks of trespass into any land contravening section 4.1 of the Act. So anybody trespassing into a government property for mining operations, then the government can book under section 21 subclause 3 of the Act. Then trespass into any land is also an offense under the Act, 21.3 of the Act. Then the government shall serve on the trespasser order of eviction, and then with help of police evict the trespasser and take back portion of the land of the government. So there is no provision for this trespasser going to court and asking court to grant arrest government injunction restraining government from dispossessing him or it unless it follows the due process of law, as is the case with the lease of property under the Transfer of Property Act or rent statutes of various states. Then 21.4 states that you must have license to transport or raise any mineral of any kind, and in that case, if there is carrying of mining operations or transport of mining minerals without permit, then the authority can seize the vehicle or tools or equipment as the case may be for breach of section 21 subclause 4 of the Act. 21.4 is seizure of mining minerals, seizure of equipment, tools, vehicle, or other thing used for raising or extraction and for transporting or caused to be raised or transported without permit. So this is also made a penal offense 21.4. 21.4a speaks of confiscation of minerals, confiscation of tools, vehicles, equipment as per order of the court. So with that, the next point is section 22 of the Act, that is complaint by the person authorized by the government for launching prosecution against the offender for violation of provisions of Mines and Minerals Act. The question is whether the police can file complaint suo motu or by itself for contravention provisions of MMDR Act, or whether only the authorized officer of the government, say Inspector of Mines and Geology, or officers empowered by the government, they only shall file complaint. That is section 22 of the Act. That is the aspect of the complaints by authorized persons. So the Act says for contravention of provisions of MMDR Act, there shall be a complaint before the magistrate under the provisions of 22 of the Act to be filed by only authorized persons. Failing which, the complaint is said to be bad in law. So, filing of complaint, filing of charge sheet by the authorized officer of the government under MMDR Act is important, and the police have no power to investigate the offences involving contravention of provisions of MMDR Act, and it is only the authorized officer who shall file the charge sheet before the concerned court under section 173 of the CRPC. With that, section 23B speaks of power of search. So only a gazetted officer or authorized officer, as per the government, state government or central government, they can seize, they can search. And here section 100 of the CRPC applies. So only a gazetted officer or authorized officer under the central or state government's notification, they only have the power to search, and even to cover the police also. The GO must state that police are empowered. So here, power of search under the MMDR Act is by the officer who are called as gazette officer or authorized officer authorized by the central or state government. So we should see the government notification and then go forward to know whether the person in question has the power to search or not under section 23 capital B of the MMDR Act. So these are all the new things, and provisions of a special statute, they prevail over even general provisions of the APC or even CRPC. So, special statute, what it contains, those provisions, they prevail over other provisions of the CRPC, even though the said provisions conflict or are quite contrary to the provisions of the CRPC or other penal provisions. So with that, 30B is what is called as creation of the new courts by the government called as special courts only for trial of cases involving contravention of provisions of the MMDR Act. Contravention of section 4 of the Act, 4, 41, 41, 441 or 43 of the Act. So contravention of provisions of the MMDR Act, the trial of the cases must be by a special court under 30B of the Act. And this law is in place for the past 6 years. Now I got in all the states in our country special courts under 30B of the Act created by the government on the recommendation of the CG of the concerned state. So I got special courts at all the district headquarters in all the districts in our state, and as per notification of the government, the creation of the special courts. So offences involving contravention of provisions of MMDR Act for the past 6 years are under the realm of the special court. So the court of GFC, which had the powers previously, now has no power to try a case involving provisions of breach of provisions of MMDR Act. Only special court headed by a judge of the rank of a district and sessions judge has the power to try the case, and the High Court has to recommend to the government to appoint so and so as a special judge for the special court. So, in the state of Karnataka, where I got the special courts been created by the government as per notification of 17th of March of 2016. So many other state governments, they must have passed similar notifications creating special courts under 30B of the Act for trial of cases under the provisions of MMDR Act. In all cases which were before the courts of JMFC as on the dates of creation of the special courts under 30B of the Act by the concerned state governments, they get transferred automatically to the special courts for trial because of change in law with effect from January 2015. So, with this, the next important point is the aspects of case law of the Supreme Court of India on the aspect of MMDR Act. And the first case which I will take up now is the case reported in 2020 Part 2 SCC page 768. The case name is what is called as M.E. Shivalinga Murthy versus CBI Bengaluru, Karnataka. In this case of Shivalinga Murthy, there was there was confirmation of Rule 37 of Mineral Concession Rules of 1960 and also Rule 37 of Mineral Concession Rules of 1949. So here in this case, the accused M.E. Shivalingamurthy applied before the special court at Bangalore for discharge under section 227 of the CRPC. And in this case, the appeals court held in very clear terms that for discharge of the accused by the special court or by any court on section 227 of the CRPC, the defense of the accused before the court as per records cannot be looked into. So in this case, in the context of MMDR Act and also general principles of law, the appeals court held for discharge of the accused, what the court can look into is only charge sheet filed by the IO or by the police or by the authority under section 173 of the CRPC. Defense of the accused, the court cannot look into at the stage of hearing of the application filed by the accused for discharge under section 227 of the CRPC. So in this case, in the context of MMDR rules contravention, the appeals court held and laid down the broad principle of law that for discharge of the accused, court should look into only the charge sheets and records of the prosecution or the state or CBI or as the case may be, and not the defenses or the records which the accused may go to court at the time of arguments on IFR discharge. The second case is State of Meghalaya versus all Dimasa Students Union, Dima Hasao District Committee and others. That is 2019 Part 8 SCC page 177. Here sections 2, 4, 5, 13 of MMDR Act they are involved, and so also minor concession rules of 1960, provisions of Transfer Property Act, Article 244 of the Indian Constitution. In this case, the appeals court held in very clear words that with regard to privately owned, or community owned lands in the hill districts of Meghalaya, MMDR Act and rules applies and mining lease to be obtained for mining operations. It's a case of a mining operation which was done by the persons in the hills. So, with regard to privately owned or community owned lands in hill districts of Meghalaya, the appeals court held that MMDR Act and rules applies and mining lease must be obtained even for mining operations in the hilly areas of the hilly districts, the said hill or hills being owned by the community in general or owned also privately. So the point is hilly area, and we want to extract the mining thing at the hill areas owned by a person or a community. The Supreme Court held that that requires permission, failing which there is breach of provisions of the Mines and Minerals Act. Then nextly we have got the case of the apex court in Kanwar Pal Singh versus State of UP, that is 2019 SCC Online Supreme Court page number 1652. In this case, the judgment was delivered on 18/12/2019 by the Supreme Court of India. Sections involved are 4 and 21 of MMDR Act and also Section 379 of the IPC. I told previously, in a case of theft of sand or minor minerals, there may be two contraventions, one under the provisions of IPC, number two under provisions of MMDR Act. For IPC, the section is 379, MMDR Act it is section 4 and 21. So here, in the case of Kanwar Pal Singh versus State of UP, 2019 SCC Supreme Court online page 1652, the apex court held that prosecution and cognizance of the offence by the magistrate under section 379 of the IPC was upheld by the apex court. So magistrate had the power to take cognizance of the charge sheet filed by the police under section 378 379 of the IPC, and also in this case there was also sections 3 and 4 of prevention of damage to public property act. So the apex court held that the magistrate had the power to take cognizance of the offences under section 379 of the IPC regarding theft of minor minerals, theft of sand, etc., and that is the dictum of the apex court. In this case, the apex court followed its earlier judgment. In the case of State of NCT versus Sanjay, reported in 2014, Part 9, SCC, page 772. So, the Supreme Court of India in Kanwar Pal Singh versus State of UP followed its ratio in State of NCT, Delhi versus Sanjay, 2014, Part 9, SCC, page 772, wherein the apex court held that the magistrate had the power to take cognizance of the charge sheet filed by the police on section 379 of the IPC. So, for theft of sand under the IPC, magistrate had the power to take the cognizance and go forward. And this charge sheet need not go before a special court under section 30 capital B of the MMDR Act. In this case, the apex court further held that for breach of provisions of MMDR Act, prosecution and cognizance under 21 of the MMDR Act and 4 of MMDR Act by the magistrate was held by the apex court as not valid and justified in the absence of authorization under section 22 of the Act. So, charge sheet filed by the IO of the authorized officer under the MMDR Act is primary for the court of magistrate to take cognizance and commit the said case to the court of sessions, namely special court. So without the charge sheet filed by the authorized officer for breach of sections 4 and 21 of the MMDR Act, the apex court in the very same case, Karnataka Singh held that prosecution and cognizance under Section 21 of the MMDR Act and 4 of MMDR Act by the magistrate is not valid and proper and justified, and set aside that portion of the order of the magistrate who had taken cognizance of the offences under the MMDR Act, also sections 4 and 21. Then nextly, the case of State of NCT, Delhi versus Sanjay 2014 Part 9 SCC page number 772, of which I told just now. This ratio the Apex Court followed in the first case of Kanwar Pal Singh. So in this case of Sanjay, the Apex Court held that in case of theft of minerals, including sand from riverbed, sections 378, 379, and 414 of the IPC will come into play, and police can take action under purviews of the IPC, sections 378 of the IPC, and police have no power to take action under Section 22 of the MMDR Act. The Apex Court held that 22 of MMDR Act is not a complete and absolute bar for taking action by the police for illegal and dishonestly committing theft of minerals, including sand from the riverbed. For theft of sand on riverbed, police can file complaint, police can investigate, police can file charge sheet, magistrate can take cognizance. That requires no complaint of the authorized officer on section 22 of the MNDR Act. The Apex Court held that magistrate has jurisdiction to take cognizance for offence under 378 of the APC without awaiting for the receipt of complaint that may be filed by the authorized officer under MMDR Act for taking cognizance in respect of violations of the MMDR Act. So with that, the next case law of the Apex Court, which I would like to touch on the aspect of contravention of MMDR Act, is namely a case of recent time, that is Jayant versus the state of MP, that is 2020 SCC online, Supreme Court 989, Jayant versus state of MP. Date of order is 3/12/2020, sections 4, 21, 379 of the IPC, 4 and 4 of the IPC, and section 156 surplus 3 of CRPC that are involved in this case of Jayant versus state of Madhya Pradesh. 2020 SCC online, Supreme Court page number 989. At para 15, para 13 of the above order, the Apex Court held in very clear terms that the magistrate had the power under section 156 surplus 3 of the CRPC to order or direct the concerned in charge or SHO of the police station to lodge or register the crime case or FIR even for the offences under provisions of MMDR Act violations and rules made thereunder, and at this stage the bar under section 22 of MMDR Act shall not be attracted. So this question I had posed you in the beginning as a question to be discussed now, and now the time has come. So the Apex Court held at para 13 that the magistrate, in case of a private complaint under section 200 of CRPC, had the power to direct the police, the local police, to investigate the offences involving even contraventions of provisions of MMDR Act, along with IPC or other offences. And the Apex Court held that the bar under section 22 of MMDR Act shall be attracted only when the magistrate takes cognizance of the offences under the MMDR Act. The Apex Court held that the magistrate cannot take cognizance of a case under violations of MMDR Act unless the charge sheet or complaint is filed by the authorized officer under section 22 of the MMDR Act. So the bar under the provisions of 22 of the MMDR Act shall be attracted only when the magistrate take cognizance of the offences under the MMDR Act. So, and the Apex Court held that for commission of offences under the IPC on receipt of police report, the court of GMC can take cognizance and proceed further. And for violation of provisions of MMDR Act or rules, the magistrate has to pass order directing the in-charge police station to register or lodge crime or case for violations of MMDR Act as and when the authorized officer lodges complaint, or the consent court can direct the authorized officer also to file complaint before the magistrate, and that thereafter the court will take cognizance. So the ratio is the court of magistrate has the power to direct the police to investigate on the aspect of contravention provisions of MMDR Act, and at that stage the bar under section 22 of the MMDR Act does not apply or come into play. That is the ratio in the above case of the above case which I told you, the case of Jayant. So the Apex Court held that, however, the bar under section 23 capital A subclause 2 of MMDR Act shall not affect any proceedings for the offences under IPC, such as sections 379 and 414 of the IPC, and that the same shall be proceeded further. The next point is we got the case law of the High Court of Karnataka, Sri Vivek versus the state of Karnataka, 2017 SCC online Karnataka, page number 4725. In this case, the High Court of Karnataka held that the magistrate, on receipt of charge sheet filed by the authorized officer of the government under 22 of the MMDR Act, shall send or commit the charge sheet along with the records to the Court of Sessions, namely the special court under 30B of the Act, and that thereafter the said special court will take cognizance and proceed further. So that is the principle of the High Court of Karnataka in the above case, and that is the general principle of law even under the IPC provisions also. The offense of murder, section 302 of the IPC, a case is to be tried by only the court of a session judge. Here, the charge sheet is filed by the IO before the magistrate court, and the magistrate, he will commit the case to the court of sessions, and the same principle applies to a case triable by a court of sessions, namely special court, for contravention of provisions of the MMDR Act. So with that, the next point is release of the vehicle seized by the police, or release of the vehicle seized by the authorized officer under 22 of the Act. Whether the magistrate has the power to release the vehicle which is seized by the authorized officer of the state government or central government for contravention of provisions of sections 4 or 21 of the MMDR Act or not is the question. So for release of vehicle, what is the case law of the Supreme Court of India? So we got here the important case law of the Apex Court, that is Sundar Bhai Ambalal Desai versus State of Gujarat, reported in AIR 2003 Supreme Court, page number 638. So the magistrate has the power to release the vehicle seized even by the authorized officer of MMDR Act or by local police for contravention provisions of the IPC or also MMDR Act, and this decision is the stock decision of the Supreme Court of India. The case is Sundarbai Ambalal Desai versus State of Gujarat, AIR 2003, Supreme Court 638. In this case, the Apex Court has given guidelines to the police stations, guidelines to the trial courts, the magistrates, as the case may be, and the purpose of this decision is the property seized should not rot in the police station or in the court premises if they are not released for a long period of time. And the Apex Court observed that we see in many of the police stations and in law courts vehicles being seized and not being claimed by any person, and that the said vehicles, after a gap of time, the value will be even zero, or that they are damaged on account of non-use. And the Apex Court laid down in the case of Sundarbai Ambala Desai various guidelines. So, as per these guidelines, the trial courts or JMC court had the power even to order for release of the vehicle seized by the police or by the concerned authority on the provisions of the MMDR Act. So that is the case of, Sundarbai Ambalal Desai. So with this, I think I have touched the aspect of legal issues involving provisions of Mines and Minerals Act, and that, as we all know, the special court under MMDR Act has the power to grant anticipatory bail on section 438 of the CRPC. That power is there, and the special court can grant anticipatory bail to the accused who is facing arrest for contravention of provisions of MDR Act. So that is the aspect of the MMDR Act. So grant of anticipatory bail is permissible, and the session court can grant anticipatory bail in the fit cases. With that, the next point is State of Rajasthan versus Deep Jyoti Company 2016 Part 5 Supreme Court cases 120. In this case, the Apex Court held that minor minerals in quarries are property of the government. The Apex Court held that minor minerals in the quarries are property of the government, and for that there must be permit required to take minor minerals. That is the Apex Court decision 2016 Part 6 SCC page number 120. And with regard to illegal mining, the Apex Court in the case of B.R. Surendranath Singh versus Union of India reported in 2011 SCC Part 5 page 449 held that lease could legally lessee could legally mine up to 5,500 metric tons in a year, and held in this case that the theory of somebody else having put 1 lakh ton of iron ore of mining lease was not tenable, and the Apex Court held that 1 lakh ton of iron ore cannot be kept on any mining lease all of a sudden without knowledge of the lessee. And the Apex Court held that the lessee cannot have any right over the seized iron ores. So the ratio is lessee could legally mine up to 5500 metric tons in a year. That is the ratio, and if it's beyond that, it's called as illegal mining. And for that illegally mined I mean, minerals, lessee cannot lay any right. In this case, iron ores was seized by the government. And the last case is state of Gujarat versus Nirmala Bain Mehta. In this case, the Apex Court is 2016 Part 9 SCC 240. The Apex Court held that new conditions of extraction of mineral can be imposed to on the lessee only at the stage of renewal of mining lease, since renewal is a fresh license unlike an extension. So the Apex Court held that the government cannot impose new conditions in the existing mining lease. Only in case of a renewal being applied for, then the government can impose new conditions. And the Apex Court held that sorry, renewal of license is grant of a fresh lease and is not a case of extension. So, with this, I completed the aspect of the practice and procedure regarding provisions of Mines and Minerals Act, and I have touched only the legal niceties involved before the law courts. If the viewers have got any doubts or queries on what I have told regarding the aspect of practice and procedure or difficulties which they must have faced in the law courts regarding provisions of application of the MMDR Act, they may kindly ask me and I will try to assist them by giving the answer covered by the decisions of the Supreme Court of India. Yes, Mr. Vikas. I think you have to unmute.
In fact, that technical man was there, and I was watching on the
Okay,
YouTube. So there's some time lag in that. I'll just check as to
okay,
whether we have any questions.
okay, okay.
So whether dead rent is payable in the Batwadi land.
So I spoke of dead rent, I spoke of royalty, and I also told about the case law of the Apex Court. And here, section 9A of the Act is important. Dead rent is payable on a mining lease in addition to royalty, and the same is payable whether mine is worked or not. I gave here the example of a landlord and tenant. A tenant takes a premises on rent, locks it, goes to some place for 3 months. That tenant cannot say to landlord that for 3 months I have not used, I won't pay the amount of rent. The landlord says, use or no use, you pay rent. Here also, dead rent is said to be a rent which is calculated on area of land, whether you extract any minerals or not. So, dead rent is called as a fixed return to the lessor to be paid by the lessee. Lessor is government, lessee is the licensee in question, as the case may be. So, dead rent is what's called as a fixed payment to be made by the lessee to the lessor, whereas royalty is a variable return to the lessor. So royalty is fixed on the area of land worked out for winning or obtaining minerals. So say we take on rent a car and the car owner says, yes, whether you use it or not, you pay me minimum charges. So it's on the same footing. So dead rent is a rent payable whether we work or not the mine, that is a fixed amount which is reckoned on area of land. And once you start taking minerals from the concerned land, then you have to pay what's called as royalty based on the minerals which are extracted by the licensee or the lessee in the case. That is D.K. Trivedi versus State of Gujarat, reported in AIR 1986, Supreme Court, page number 1323. Only for Mining Act only, Supreme Court of India has given this decision. Yes, sir.
So what is a reconnaissance permit?
So reconnaissance means that is issued by the government for 5 different purposes. So the word reconnaissance means, say we want to survey whether there are mineral deposits in a forest area or on the hillock of a given place. We cannot go there and physically verify. And the government issues what's called as a reconnaissance permit. Under section 3, subclause H, subclause B of the Act. 3HB is meaning of permit which is called as reconnaissance permit. So there is issuance of this permit for 5 purposes: regional survey, aerial survey, geophysical survey, geological survey, and geological mapping. So permit is issued for so and so area, say 5,000 hectares of land. You want to survey, you must take there what's called as reconnaissance permit for regional survey. That is called as geophysical survey. Physically you want to verify. So that is first type. Then regional survey, area wise, aerial survey. So over the aircraft also we can make survey which particular area is forest area, which area is hilly area, which area is dry land. So there can be also aerial survey. Then geophysical survey. Fourthly, geochemical. Then lastly, geological mapping. So if the area of land is very vast, we cannot take mining lease of a given hectares of land. So here the question is, large area of land to be surveyed is there, then we should obtain for reconnaissance permit. That is the aspect of 3HB of the MMDR Act.
Yes, sir. So that was the last question.
Okay.
And we are so grateful that despite the fact that you are broad, still you have taken the session. And thank you, friends, for being connected with us. And tomorrow we have a session on the Justice Ramkumar series on charge and discharge, part 5. So do stay connected with us at 4:30 tomorrow. Everyone stay safe, stay blessed. Namaskar.
Namaskar. Namaskar.